all rise. The Court of Appeals Division 1 is now in session.
Please be seated. Thank you all for being here this morning. We're here in our case 1 CACV 13-0778, and it's Harvey versus Phoenix Airport Marriott. Each side will have 20 minutes to argue, and appellant may save time for a rebuttal, but you'll have to manage your own time and keep track of that. The clock is on the podium. We are recording the argument, both audio and video. We're doing that new this term, and in a couple of days, the argument will be on YouTube, so you can all go on YouTube and see how the argument went. As you come forward, please identify yourself and your client so that when we listen to the argument again, we'll be able to tell who's speaking. We've read the briefs and conference the case, so we're familiar with the facts and the issues, so you don't need to rehash your case. You may begin your argument. Counsel, you may begin.
Thank you, Your Honor. Robert Edwards, appearing on behalf of Janet Harvey. May it please the court, as I was preparing for this argument, I read my brief again and researched the cases again and noticed that I'd made some small errors that I wanted to bring to your attention. Nothing major, but I cited the Daubert, I think that's how you pronounce it, case from the Ninth Circuit for the proposition that trial court always has to hold a hearing when there's a dispute like this. Well, they changed that rule. They modified that in another case that I cited, Mukhtar versus Cal State University. Now they don't require that in every single case, but they do require some proof in the record that the reliability analysis was done. And in that Mukhtar case, they commented when they reversed the trial court that the only evidence they saw that such a reliability determination had been made was the fact that the testimony was allowed over the objections of the other side, and that wasn't good enough. I also cited a case called, I think it's Hisenaj, Hisenaj versus Kuhner. That's from New Jersey, for the proposition that it was reversible error to allow the testimony of a biomechanical engineer. Well, the Supreme Court later reversed that decision, which was from the Court of Appeals, on procedural grounds, because the Court of Appeals had gone beyond the trial court record to reach the conclusions it did, disqualifying the biomechanist. The Supreme Court didn't disagree with those, with that portion of the case. In fact, they went on to say, well, if these errors were developed in the trial court, you probably would have been well within your grounds to keep this out, but it wasn't, so it has to go in. And then I cited Smelser versus Norfolk Southern Railway Company for the proposition that once this biomechanical testimony was admitted over objection, the result was a new trial on damages. Turns out that that was the plaintiff's biomechanical expert who testified, and the appellate court decided that it was unacceptable testimony, and that was the only testimony on causation. So the matter was remanded for entry of judgment for the defendant.
Well, Counselor, how does all that affect your argument here?
Well, because I got it wrong in my brief and I didn't want you to compound the error. That's all. I just want to make sure that it gets cited correctly if it does. I graduated from Arizona State University in 1973. Before they'd let me out, they forced me to take an advanced math class, which filled me with a little trepidation because I'm not good at that. So I looked through the course offering schedule to find the easiest thing I could, at least sounded easy, and settled on probability and statistics. And the professor there loved to illustrate the concept of the day with examples from the dog track in Phoenix. You know, like what are your odds of picking the trifecta, that sort of thing. But he'd always say at the end, once the race is over, probability and statistics don't matter. And so when I saw what Dr. Hannon was proposing to do in this case, I immediately knew that it was, at least from a statistical standpoint, fallacious. And he, by the way, is not the only person doing this. There's a Dr. Pellis out there who's doing it, and Robert Anderson who's doing it.
Counsel, were they involved in this case?
No, they were not.
Okay.
No, they were not. But I just want you to know that Dr. Hannon is not the only one doing this sort of thing. In this case, as I tried to point out, there were a number of errors made by Dr. Hannon in his assumptions, and when you make errors in the assumptions and then you apply math and whatever to the assumptions that are wrong, the result is wrong too.
Counsel, you knew about those alleged errors at the time of trial, or
yes,
or before. So I assume that you brought that out on cross-examination.
I tried my best. Yeah, I tried my best. I agree. However,
then
yeah,
whether that evidence comes in is, but that's for the jury to figure out. Correct?
No, not anymore. Not anymore. In the old days, that was the deal. But now, under this new rule of evidence and under Dalbert and all the cases that followed, that sort of testimony doesn't get to the jury at all, and I don't call my people. That's the rule. And one of the cases I cited in my brief talks about that very point, and I think it was the Mukhtar case. I'm not totally sure on that, but one of the cases I cited had that same argument raised. Well, couldn't you just deal with this on cross-examination? And the appellate court said no. It's too easy for the jury to get lost in these complicated theories, and when evidence is presented as a reenactment of what really happened, then it takes on a life of its own, and that's exactly what happened in the case I cited, which I, like the name I can't find, but I will, and I'll save some time on my rebuttal to bring it to your attention.
Counsel, let me ask to make sure we're working on the same legal standard.
Yes, sir.
The issues raised with respect to the expert testimony here spanned both the time when Arizona was a Fry state and then the new Arizona Rules of Evidence, or the revised Arizona Rules of Evidence, correct?
In a sense, yes. But
let me tell you why I think that's true. Because Arizona became a Daubert state on the 1st of January 2012.
Right.
Your motion was fully briefed, or the motion to preclude the expert testimony was fully briefed prior to that time. The decision and then the trial occurred after that time, correct?
True.
So it seems to me that the standard that we should be applying here, considering, is the rules of evidence as they were amended the 1st of January 2012. Do you agree?
Dalbert.
Do you agree with that?
I agree with that. Okay. I briefed both at the time because, I was just being careful.
You briefed both at the time because Arizona was not a Daubert state.
Right.
Which is fair. Now, the admissibility of evidence under the new Rule 702 is subject, unlike Fry, which was a de novo standard, is subject to abuse of discretion standard review. Is that correct?
Yes, correct as far as that went. But whether or not the trial court performed the appropriate analysis, that's a de novo, and the trial court gets no leeway there.
What ground do we have to suggest that the trial court used the wrong standard as opposed to, from your perspective, applied it incorrectly?
Okay, well, I don't think it's impossible to tell from the decision what standard was applied, but I should point out.
Should we, if it's impossible to tell, don't we assume that the applicable law was applied as an appellate matter?
No, I wouldn't do that, because for two reasons. I also filed a motion for reconsideration, which was denied after January 1st, 2012. So that order, I think, should be based on Daubert or Daubert.
I think
Okay.
we're saying the same thing.
Okay.
I just want to make sure, because Fry, generally, novel scientific evidence was subject to a de novo appellate review.
Okay.
Very small subset of expert testimony, but that
Right.
was Fry.
Right.
Fry doesn't really apply to this case as the way things turned out. Do you agree?
Oh, yes, I agree.
So if that's the case, we're under the new Rule 702, which suggests to me we're looking at abuse of discretion. Did the trial court abuse its discretion in allowing this evidence to go to the jury? Unless there's a showing that the trial court applied the wrong standard, which I heard you to say we can't determine that.
No, if you look at the Mukhtar case from the Ninth Circuit, they had virtually the identical fact situation, a motion objecting on Daubert grounds, no real discussion by the trial judge, and the evidence comes in. And they said, no, that's not good enough. We need proof in the record that the trial court went through all the appropriate steps in their analysis. We won't second guess the result of the steps, but you have to show us that you did all the things that are required and you dealt with all the issues that were raised by the objecting party.
And is that type of inquiry unanimous in the circuits?
I have not found a case where it wasn't. I have not found anything where it was not, where they said, no, you have to do this. If you look at that Flickinger case versus Toys R Us, which is page 1 of your appendix, there you've got Judge Caputo, I think out east somewhere.
District court decision.
District court. But
Exercising discretion that evidence would
Right.
not be received, right?
But you see how thorough he was.
Does that case suggest that had the trial court gone the other way, that there would have been an abuse of discretion?
What do you mean?
the
If he
trial
said
court
the evidence
admitted it,
comes
yeah.
in?
In other words, it's a deferential standard.
Well,
It's
yeah,
different than Fry.
to a point. Yeah, I don't know how the appellate court would look at that if they got a hold of it. If he went through and pointed out all these methodological flaws and then said, but it still comes in, I haven't found a case where that happened.
Well,
so
we
I
also
don't know.
don't have a Third Circuit decision affirming the decision excluding that evidence either. Right?
No, we don't. No, it just went away after that.
Right, which happens.
Sure, yeah. But I can tell you this. In all the cases I read, whenever a biomechanist was allowed to give opinions like were given in this case over properly laid forth objections, the result was always reversal. In every case, I could not find one where they determined that it was harmless error or anything like that. It was always reversal.
No, go ahead.
Counsel, so you're saying that the record doesn't show that the trial court applied the correct analysis?
That's exactly.
I thought that the law in Arizona was that we presume that trial judges know and apply the law, and if we're faced with a silent record, don't we, shouldn't we presume the trial judge did what the law required him to do?
I don't think you should. I haven't found a decision that allows that, and the Ninth Circuit has made it clear we've got to see evidence that this analysis was done appropriately.
But,
We were not,
but there's no Arizona
I know.
opinion that says that.
No, because to my knowledge, this is the first case under this rule, at least that I've seen, where we got here to this point. So you get to make sort of out of whole cloth, but not quite.
And let me ask you, just to clarify, to follow up on
Yeah.
your first corrections, and I appreciate what you have told us. You are not arguing that your client had a right to a pretrial evidentiary hearing. You're claiming that the trial court abused its discretion in failing to hold that hearing. Is that fair?
No, I'm not saying there's a right. The Ninth Circuit backed off from that, and all the other circuits, at least what I found, seem to have done that. There's no hard and fast rule every single time, but there is a hard and fast rule. Every single time, the appellate court needs to see proof that the trial court went through all the appropriate steps of the analysis to arrive at its decision.
And that's based on the Ninth Circuit decision that you and Judge Howe
And
had
others too. I mean, I've not found one that went the other way, so.
Understand.
And none was cited in the respondent's brief. So, unless you've got further questions, I did want to make a brief comment on the McDonald's coffee verdict issue in this case and my reading of the rule. The comments to the rule say that disclosure 30 days before trial of non-disclosed evidence, so to speak, is presumptively prejudicial. And so my feeling is the rule, when it's disclosed during trial, you've somehow gone beyond presumptively prejudicial, and it becomes a fact.
Can I ask, was there a timely contemporaneous objection to that testimony?
No, I did not.
Or to the closing argument?
No, neither one. Neither one. My, as I point out in my brief, I think the rule is you disclose first.
And I understand the arguments.
Okay. And that leaves me with 5 minutes, and I'll reserve that. Thank you.
Thank you, counsel.
Your Honor, may it please the court, my name is Eddie Doman. I represent the defendant, Phoenix Airport, Marriott. I want to touch a lot on Dalbert since that's the main thing that we've been talking about. First of all, when we talk about how there's been no decisions upholding the trial court, we just talked about one. In the state of New Jersey, as counsel correctly pointed out, the case cited in his brief was reversed on appeal by the New Jersey Supreme Court. The citation for that decision, if you'd like to read it, is 194 New Jersey 6. One of the things that court dealt with, it wasn't just a procedural issue. If you read the entire opinion, you'll see that they go through how the evidence was appropriate. And in a lot of the complaints regarding what Dr. Hannon did in this case, the complaint ends up being that you don't have a testing sample of a 56-year-old woman. If you read his cross-examination of Dr. Hannon, that's stressed over and over again to attempt to say you don't have a study that meets this exact criteria. Well, when the New Jersey court did overrule the appellate decision that's been cited to you, they said, as noted, plaintiff argued that Dr. Alexander's reliance on the studies were flawed because the studies did not include a 41-year-old woman with asymptomatic degenerative disc disease involved in a collision with a delta V under 5 miles an hour. According to the plaintiff, an expert would be required to rely on a study that precisely mirrored the type of injury sustained by a similar featured plaintiff before a court could admit the testimony of an expert who relied on such testing and related scientific literature as a basis for the opinion. That position is clearly inconsistent with existing law, however. So when the New Jersey court looked at this issue, looked at a case that was being relied on to you as to why this case should be reversed, they addressed the primary argument that exists here regarding the other tests that we're dealing with, and they said that in certain cases it's not appropriate to assume that the literature being relied on is not correct only because it didn't involve the exact same sort of sample. I think it's interesting that we're talking about the Flickinger case considering it's unreported and never should have been cited to this case pursuant to your rules. 28A specifically, I believe, another one of the cases is the same concept. It's unreported and shouldn't be considered.
Counsel, let me ask you to see, you've heard me ask some questions of opposing counsel to make sure that at least the rules of engagement that we're on are, there's some agreement there. Do you agree that the rules as of the 1st of January 2012 apply and not the pre-existing rules?
Your Honor, I don't believe it's entirely clear, but I think that more than likely that's correct, since the trial did actually take place after that date.
Okay. Do you, with respect to the thought of whether a pretrial evidentiary hearing was required or not, is it your position that the plaintiff had no right to such a hearing? Such a hearing could have been held, but it's a discretionary call?
Well, yes, Your Honor. I mean, I think plaintiff's counsel conceded that, and the court's already ruled on it.
I think plaintiff's counsel did too, but I wanted to make sure all three of us, or all five of us, were on the same page.
Yeah.
And then with respect to the admissibility of the expert testimony, what is the appropriate standard of review for this court to use?
What, Your Honor, I think it's clearly an abuse of discretion standpoint. In the Klein case, when Arizona specifically recognized a hearing wasn't required, they said that it was an abuse of discretion standard, and in essence, they said that whether or not to have the hearing also fell within that general abuse of discretion standard. In this case, I actually think the abuse of discretion standard goes a step further, because as you mentioned, when the initial briefs were filed, we were dealing with a different rule of evidence, and maybe we were dealing with Fry. And then there's a motion to reconsider that, in fairness, because of the procedure with motions to reconsider, we weren't allowed to file a response to, and the judge just denied it. But what I think is extremely important in this case is the fact that there was a motion for a new trial filed on this basis, which means the trial court again considered the issue after hearing the testimony at trial regarding the methodology that was used, and also after reviewing the experts' reports, and determined that under the trial court's opinion that this testimony of Dr. Hannon was proper under Dalbert. So we really have three decisions, the last of which is a looking back onto what happened and what testimony existed at the trial court level, where they again found that the testimony was correct.
Well, and let me ask you, because this implicates the standard of review. Do you agree that two trial courts sharing a wall in a courthouse under Daubert, not Fry, but Daubert, could find one trial judge one could find yes, it comes in exercising the court's discretion. Trial judge two could find no, it doesn't. An appeal comes up in both those cases to the same panel of three appellate judges, and both those could be affirms. Isn't that how the standard works?
I believe that's absolutely true, Your Honor. I think several cases have actually mentioned that exact same thing.
And the reason why I say that is to me that suggests that precedent in this context may be somewhat less helpful than it was under Fry. Because the question is not, did the trial court get it right? The question is, did the trial court abuse his or her discretion in allowing or excluding the evidence? Do you agree? Yes,
Your Honor. I absolutely agree. And there's several cases out there where the court would say explicitly in its opinion, based on this record, if the decision would have gone the other way, we would have also affirmed. But because we're dealing with an abuse of discretion standard, that they find that discretion wasn't abused.
And please, if you would, address the argument made by appellant that because that states the trial court didn't sort of show us his math, which is always helpful, frankly, for review. And then secondly, if you agree as a factual matter that's true, that requires us to look at the case differently than had the work been shown.
Right. First, I want to point out that, as you correctly noted, this court, in its opinions, has consistently held over the years that this court will assume that the trial judge knows and follows the law. This court has always said that when reviewing matters. As it relates to the math, so to speak, in this case, if you look at the judge's initial denial of the motion, he does state, for the reasons stated in the defendant's response. And when you look at the motion and you look at the response and you look at how they attached the various reports and the complaints about the testimony. The trial judge had all of the relevant information for him. The fact that he didn't take the step to type out an order going through the reasons stated in our response shouldn't change the way that this court reviews his actual decision. There's no evidence he was unaware of Dalbert and didn't consider the relevant factors. And when you look at the methodology used, it's described. You know, we're dealing with Newton's laws of physics and gravity and forces, and, you know, on certain things, the trial court has the discretion to decide what's appropriate. And again, I think it's important that he did so again after the trial in this matter, because that decision as to whether or not to grant the motion for a new trial is an abuse of discretion factor as well. So on 3 different occasions, he decided that Dr. Hannon was appropriate.
And because I assume on each occasion, the parties fully briefed the issue and dealt with the math as Judge Summer puts it.
Well, the first and the third time, certainly, Your Honor. The initial motion to exclude, it was fully briefed by both sides. The same thing is true when it was briefed as it relates to the motion for a new trial. To be fair, on the motion for reconsideration, we weren't allowed to file a response, so it wasn't fully briefed as it relates to that second decision.
Thank you.
And again, as it relates to the math itself, I also think it's important to note that one of the cases cited to is from New York. New York decisions after that case have actually dealt with the issue of whether or not a specific G-force can cause an injury. In the case of Valentine versus Grossman, the cite's 238 AD 2nd 571, the court reversed a trial court that didn't allow a biomechanical engineer to come in and testify that when an accident occurred with 3.6 Gs, that it couldn't cause a herniated disc. And I think when you look at the evidence, I just want to briefly touch upon the fact, because a lot of the briefing is devoted to this, that it's inappropriate to use the testing as it relates to prize fighters, airmen, football players. The reason is inherently obvious, because we don't subject human subjects to physical tests. And so sometimes, and the literature reflects this, AD did some articles from their biomechanist, Dr. Knapp, that sometimes you have to use what's out there, and that it's not inappropriate to use what's out there to a particular situation. And as it relates to this case, I think it's important because one of their complaints is that Dr. Hannon was coming in and saying he knew what the lower level was for a mild traumatic brain injury as it relates to G-forces. But if you read his reports and you read the testimony, what he actually says is, I've looked at these studies, I've looked at these articles. If you go back far enough, there's somebody that says it's 40 or 42 Gs. Then there's one where it says it's 50 to 70, and then there's one that says 60 to 80. But the point is, under Dr. Hannon's analysis, the highest G-force we could have here is 1.5 to 3. And so his point wasn't that he could establish what the minimum standard is. His point is that the minimum standards that have ever been referenced are 15 times what we have here in a worst case scenario. And in that sort of situation, I think it's absolutely appropriate to apply the studies that do exist prior to, thankfully, ethical regulations being passed so we don't treat humans as guinea pigs. But I think that was absolutely appropriate, and what has to be done in this sort of situation when you're dealing with a head injury. I'd like to briefly touch on the other 2 issues that exist, one being the McDonald's case. We cited to the Mansour case from Pennsylvania that when dealing with this issue basically says if you have some brief references, it's not going to be, reversible error. In the Utah case that they're talking about, the lawyer misrepresented the facts. He was arguing specifically about the case in his closing argument to the jury. That's not what we have here. We had a lady that explained why she did a detailed report after the plaintiff came back to her hotel and asked for this champagne bottle that's at issue. And she was just simply explaining why she did this detailed report and why there would have been 2 reports in such a small temporal time period. And so there's nothing inappropriate about her explaining it. There's no duty to script her testimony to where this for sure would have come up. And more importantly, as you noted, Your Honor, is that it wasn't objected to. And the Arizona court has been clear that when you're dealing with an alleged improper argument, that you have to object. And no objection took place here. The Monaco case specifically deals with this. The one exception is if it's so egregious that the prejudice, would have been inherent. But I don't think that's what we have here.
Counsel, let me ask you if, with respect to the testimony, not the argument, but the testimony with respect to the McDonald's case, appellant argues, look, there should have been a motion to supplement as far as a disclosure matter, and there wasn't because that information wasn't disclosed previously. And I understand your argument is you didn't have to script it, you didn't have to disclose that. But a couple questions. I assume that witness was subject to deposition pretrial.
Correct.
But secondly, how does this sort of ping pong match, because you're arguing there was no objection and there wasn't at trial, but how does that work if we find that disclosure should have been made?
Well, excluding the non-objection, argument.
Well, I don't want you to exclude anything.
Okay,
It's
well,
just the appellant's argument is, look, you needed, if disclosure was required, you needed to move to allow untimely disclosure, and you didn't.
I don't believe that the testimony that we're dealing with here is such that it would have been subject to be disclosed under.
And I understand that. That comes loud and clear in your briefs. But if we don't agree with that, what is the analytical framework we follow then?
Well, at that point, there's a few things that you consider. First is whether or not that lack of disclosure and inability to file something had any sort of effect on the actual jury award. Because in a similar deal, and it did deal with the closing as opposed to the testimony, but in the Grant case that's cited in my brief, the attorney, according to the court, committed clear misconduct, made several inappropriate arguments that shouldn't have been made, some of which included facts that weren't in evidence. And even though the court very much condemned what the attorney was doing and the fact that he was doing these sort of things, this court said that, okay, look, we agree that this was bad, but it's an abuse of discretion standard as to whether or not the trial judge believed that this sort of argument had any sort of effect on the jury verdict. So regardless of the heinous arguments that were made in Grant, the court still found, look, we think this is awful. We understand the amicus brief of the people coming in and saying you're opening the gates for people to be able to just make these bad arguments with no repercussions. And the court says, listen, we hear what you're saying, but the trial court is in the best position to determine what was appropriate and whether or not it affected the verdict.
Let me see if I can play it back properly because I want to understand your argument. Do I hear you right that in my hypothetical that it would fall into the motion for new trial bucket, and the question is whether the trial court abused its discretion in denying the motion for new trial? Is that fair?
That's exactly what I'm saying, Your Honor.
Thank you.
Another minor issue that was brought up in their brief was the idea that the damages were insufficient. First, I can't believe that as an appellate issue we're dealing with an argument that you should grant a $6 million additor when the trial court awarded $5,000. There's absolutely no support for this court to interject any sort of factual finding that that sort of award would be appropriate. And on top of that, as it relates to the idea that the award was for medical bills only, in the Burgee case that's cited in my supplemental authority that was filed, the court deals with a situation where medical bills, an award was given that ended up totaling a certain amount of medical bills. And an appeal comes up based on the Muniz case, which is one of the ones cited by them for this proposition. And the court says, well, in this case, the bills were contested as whether or not they're relevant, and that we find that although it may first appear that what we have here is an award for medical expenses, since the bills were contested, it's appropriate to decide that they accepted some elements of damage, didn't accept others, and then just awarded that amount, which included an amount for general damages, which is exactly what we have here. If you go back and review the closing argument, you'll see that there were several figures talked about that were requested as far as steps along the way for these medical bills. And so on the record that we have before the court, it's absolutely appropriate to find that the damage award was sufficient and that that argument doesn't have merit. I have about 2 minutes left if any of you have any further questions.
No, thank you.
Okay, thank you, Your Honor.
Counsel.
Thank you, Your Honor.
I think that have been raised by the opposing counsel. You make the argument that the record is silent on the trial court's mouth. But as the counsel points out, the issue was fully briefed at least twice, and the trial court referenced, as I understand it, the pleadings of the parties. So isn't that enough for us to review what the trial court did?
It wouldn't be in any of the circuits that I'm aware of. So no, I would say no, you should not do that. It basically emasculates the rule then, because if you're just going to assume that the trial court did it in every case, then it just...
No, but here I thought we had more because the trial court referred to the pleadings.
Oh, right. He says for the reasons set forth. I don't think that's even close to enough. In fact, if you look at the Mukhtar case, that's exactly what happened. And the Ninth Circuit said, no, that's not good enough. It just isn't. If you look, and furthermore, even if you assume that the trial judge in fact applied the appropriate standards here, I think you would have to reach the conclusion that it was an abuse of discretion to reach that, to allow this testimony, because nobody knows where that bottle came from on its path to this woman's head. Nobody. There was no testimony from anyone. And if you don't know how far the bottle flew, or how fast it was going, or what the human tolerance for a 54-year-old woman is to sustain a concussion, how in the world can you say that's reliable and helpful to the jury?
So if I understand your argument right, there is no expert the defendant could have offered that would have met the scrutiny you believe should have been
No, you're
applied
right.
to that testimony.
Absolutely correct. Under the facts of this case, they simply could not call one of these biomechanists. And that's this underlying assumption that seems to permeate this case. Well, we picked this guy. We paid him a lot of money. Now, golly, he gets to testify. But no, I would say that under the facts of this case, with the unknowns that were out there, no honest biomechanist could testify, and no court would let them.
But doesn't that really imply a level of almost perfection before an expert could testify under 702, which I don't get from that rule?
No, it doesn't require perfection, but it requires, if you look, it requires that he follow the testimony that was given, and if there's a gap, like in the, there was a railroad case, let's see here. No, that wasn't it. Gidros Brault versus Missouri Pacific Railroad. This is where there was no testimony. The argument was, well, the engineer should have been able to see these rails gleaming in the sunlight.
Right.
And they said, well, there was no proof they were there. Out. Now, he's saying, well, I did all these calculations, which were based on a false set of facts, that she was sitting straight up, you know, with her back to the booth. And then he does all these calculations, but it's, I mean, the underlying premise is faulty, and from there you don't get the truth. All you get it's helpful for the defendant to present their case, but it's not helpful to the jury.
Let me ask, wasn't the jury provided with facts inconsistent with the testimony? I mean,
Oh, yeah, absolutely.
and so, again, well, you've answered.
Yeah,
my question.
I understand where you're going. I did want to point out that case, too, by the way. I mentioned that there was a case that I cited for the fact that you just can't cross-examine this stuff away, and now I lost it.
Well, counsel, I understand
Okay.
that the law requires something more than just cross-examination for
Okay.
evidence to be admitted under 702. What you're asking us to struggle with is whether that standard was properly met here.
Yes, and my argument is you can't do that. Oh, by the way, the amount of the jury award was exactly to the penny for medical bills. Nothing else. To the red cent. I want to make that clear. And my time's up.
Thank you, counsel. We'll take this matter under advisement and issue our decision in due course. We stand adjourned.
Is there a trash can under here? Thanks.
Thank you very much. Thank you.